Hi, this is Gila Russell, and I will be joined by Christina Morris as we tackle the case the Department of Homeland Security versus Regents of the University of California 2020. In order to really look at this case, we thought it would be best to first start at the Twitter headline and then go through our three key points. The first point being political and historical context, the second, the power of the Fifth Amendment, and then the third, the implications for tomorrow, kind of that look towards the future. And then we'll close it out. Okay, so let's get started. For our Twitter headline, we stated the following. In a narrow decision, the Supreme Court offers DACA recipients, dreamers, a glimmer of hope. They may stay in their only known home, the United States, because of the Trump administration's arbitrary and capricious attempt to end the immigration policy. This case is one in which there are so many twists and turns. First of all, it really gets at this idea that a change of guard, a change of administration has a deep impact on the type of legislation that our communities are faced with. When looking at this case, there's a couple things we want to point out. First and foremost is that term DACA recipients, also known as dreamers, okay? DACA is the abbreviation for Deferred Action for Childhood Arrivals, or DACA, okay? So you'll see that referenced or talked about throughout. You'll also see the Department of Homeland Security referenced as DHS, okay? And then you'll see these terms arbitrary and capricious, right? Arbitrary and capricious, which we'll follow through and we'll kind of delve into later as well. You'll also see the mention of APA, which you see in our Twitter hashtag. We have Twitter hashtag Dream On and Twitter hashtag Procedures Matter APA. APA really gets at this idea of process and procedures, and so we'll tackle that as well. Lastly, we'll look at the Immigration and Nationality Act, also known as the INA. So lots of abbreviations in this particular case, but they're incredibly important. Okay, let's get started. Key point number one, political and historical context, is incredibly fascinating. So you will notice that actually in our message map, we decided to put a timeline because time here really matters. You really see the difference in policy between the Barack Obama administration and the Trump administration. So I want to take you back to 2012. And in 2012, the Department of Homeland Security issues the Deferred Action for Childhood Arrivals, or DACA, under the presidency of Barack Obama. This ultimately allows for those brought to the United States as children to receive deferred action from deportation. This effort worked on a renewable 2-year basis, and more than 700,000 people applied for the initial work authorization and federal benefits that came with this new immigration effort. What's interesting, though, is 2 years later, the Barack Obama administration decides there needs to be even more. So it expands DACA by adding DAPA, or the Deferred Action for Parents of Americans. This made more than 4.5 million parents eligible for the forbearance of removal. But also in 2014, under the Fifth Circuit, Texas and 25 other states secured an injunction connected to the expansion of DACA, a conjunction basically connected to DAPA. The Fifth Circuit stated that DACA and DAPA violated the Immigration and Nationality Act, or the INA. They ultimately were saying, hey, DACA and DAPA, you guys are violating our own immigration policy. Now, what's important here is that in 2016, so we've got that 2-year extension, 2016, Trump wins the presidency. And with that, he promises to solve the immigration crisis within the United States. So fast forward, in 2017, DHS, under this new Trump administration, rescinds DAPA, and they cite the Fifth Circuit decision as the reasoning for doing so. Attorney General Jeff Sessions advised Elaine Duke, and she's acting as the Homeland Security Secretary, that the issues that are present in DAPA are actually prevalent in DACA as well. So theorizing that, it too should be rescinded. This meant that new potential recipients could not apply, and those currently in the program would see those benefits expire in 6 months. Some would be able to apply for a 2-year extension, and some would not. Those who had already received a one-time extension would not be eligible. So, of course, as you can imagine, the lawsuits began. And in 2017, California, New York, and the District of Columbia sued the government, and they sued in all separate cases. What's interesting is they all prevailed. They sued under the notion that DHS's decision was, quote, arbitrary and capricious, end quote, and that it violated the Administrative Procedure Act, or APA, and the Fifth Amendment's Due Process Clause. In the DC case, though, what's interesting is the DC District Court gave DHS 90 days to basically craft a better argument for the cancellation of DACA. Now, it's important to note that Duke is replaced by Secretary Kirstjen Nielsen, and she responds to the DC District Court's order. She keeps Elaine Duke's original argument, okay, but she expands upon it. But the court decided that this expanded reasoning did not prove that DACA was illegal, which was the government's view. So the government lost. Now, the government ultimately appeals the decision in the New York case, which was titled Wolf and Vidal, the DC case, known as Trump versus NAACP, and the California case, known as DHS versus Regents. And what's interesting, even more so, is in November 2018, the government asked the United States Supreme Court via a series of petitions that it looks at the lower court decisions, okay, and it reviews them before making a judgment, because this obviously goes all the way up to the Supreme Court. The US Supreme Court agrees to do so, to look at all the cases together, but it also consolidates them. And this ultimately means that it will lead to a decision that will apply to all. Now, before revealing the decision, which you'll hear about on key point number 2, I really want you to think about the climate during this time, okay? This case is recently decided, June of 2020, but all the years leading up to it involved quite a bit of strife connected to immigration. This is a time period in which protests occurred throughout the country with immigration taking center stage. It's a time period in which detention centers are packed with people who've crossed over the border. Remember, children have been separated from their parents, and religious organizations and groups have taken in those in need. This is the same time in which rhetoric surrounding words such as sanctuary cities, undocumented, and illegal alien swarm the media outlets. Ultimately, when historians document this time period, the case will be considered landmark. And I think ultimately, probably because Chief Justice Roberts gives that majority decision, that 5-4 decision, and him giving it also creates a landmark energy to it, considering that he's a conservative justice who appears, quote unquote, to be supporting a liberal policy. All right. With that said, Christina is going to talk about the power of the Fifth Amendment by looking at key point number 2. I then will delve into a few interesting cases that I think are really relevant here. And then we'll end with Christina really looking at the implications for tomorrow. What does our future look like with this policy in place?
In order to investigate the case further, we must understand the arguments on each side of the case. As Gila already stated when providing context, the case arose in large part due to a change in administration. Subsequently, the Department of Homeland Security decided to rescind the DAPA memorandum, which would have allowed more than 4 million parents of U.S. citizens or permanent residents a forbearance from removal. The DHS also terminated DACA, with exceptions for existing DACA recipients with benefits due to expire within 6 months, on the basis that both were legally flawed, as they violated the Immigration and Nationality Act, the APA's notice and comment requirement, which stated a legislative rule must go through a process in which the public is given an opportunity to comment on the proposed legislation, and the Take Care Clause of the Constitution, requiring the President to obey and enforce all laws. The respondents in this case, regents of the University of California, believe the cancellation of DACA violated rights outlined in the Administrative Procedure Act, or APA, and the procedural due process found under the Fifth Amendment. It is of note, both the plaintiff and respondent agreed that DACA may have been rescinded. What came before the court was the procedure that the Department of Homeland Security followed in its attempt to rescind it. The ultimate holding, founded by the Supreme Court, was a 5-4 ruling in favor of regents of the University of California. The ultimate ruling stated, "We do not decide whether DACA or its rescission are sound policies. We address only whether the agency complied with the procedural requirements that it provide a reasoned explanation for its action." Ultimately, the court believed the administration did not follow proper procedures, and it did so in a manner that was arbitrary and capricious. Importantly, the holding still offers the administration the ability to end DACA if they are able to give a stronger or better justification for the rescission. However, this is very unlikely to occur before the November 2020 elections.
in looking at what Christina just shared, the arguments and the holdings and that reasoning, we thought it was also important to mention two cases here. And the first one is connected to Marbury versus Madison. So prior to reaching the US Supreme Court, the US Court of Appeals for the Ninth Circuit actually weighed in and they rejected the government's position based on precedent set in that landmark case, Marbury versus Madison, 1803. And in that case, it establishes judicial review. The Ninth Circuit reiterated that the government cannot assert that it can avoid review when it states that its actions were legally driven. They are bound by judicial review, and it is the court's job to evaluate such laws. In the US Supreme Court case, the government's argument is really rooted in Heckler versus Cheney, a 1985 case. And that is one in which agency discretion is allowed under the Administrative Procedure Act, or APA. The government suggested that it was authorized to use such discretion. And as you see in the holding, the US Supreme Court did not quite agree.
This brings us to key point 3. What are the future implications for this ruling? With the Deferred Action for Childhood Arrivals still in place, this ruling provides protection from deportation for more than 750,000 DACA recipients, or Dreamers. It allows for these students to receive work authorizations and take part in higher education opportunities in an attempt to fulfill their dreams and those of their families. Furthermore, DACA does not exclude students or children arrivals on the basis of the circumstances of their arrival. And therein is the controversy. The Immigration and Nationality Act prioritizes relatives of U.S. citizens and legal permanent residents and professionals or individuals with specialized skills to receive consideration for legal residency. However, DACA is not exclusive in this regard and is indiscriminate when it comes to the children that are able to apply for the considerations of DACA. If DACA were to be rescinded, there would be a reprioritization of the Immigration and Nationality Act. DACA is a popular effort that helps to provide security and safety for recipients and their families. Economic, educational, and social powers can result with its successful implementation. This forbearance further impacts educational stability for children and parents as it prevents sudden removal from the country. If a child is approved for DACA, this guarantees continuity in education for at least 2 years. Consider implications for students under DACA whose parents are removed. If DAPA was rescinded, the magnitude of 4.3 million parents removed. The students would then be at risk for displacement, housing instability, and so many other adverse conditions that make it hard to learn in the classroom. Furthermore, this ruling has an implication for equity standards, considerations and policies put into place at the district levels. How do everyday teaching practices and inclusivity take into account consideration for students that may not have citizenship, but still have the right to a free, appropriate public education? An educational entitlement of all students in the United States guaranteed by the Rehabilitation Act of 1973. As educators and leaders, it is our job and duty to educate students regardless of the many variables and many factors that could impact education. Thank you so much for your mindful consideration and taking the time to investigate this case with us.